A granite supplier I had never heard of filed a mechanic's lien on my house on Chestnut Street in Mount Vernon 2 weeks before I was scheduled to close on a refinance that I had spent 4 months arranging. The lien was for $6,800. The title company called and said the lien would have to be released before they could issue title insurance for the refinance. The contractor I had hired to renovate my kitchen had not paid the supplier. I had paid the contractor in full 7 weeks earlier. The supplier had filed a lien on my house for money I had already paid to a contractor who had not forwarded it. I am an emergency room nurse. I want to say something about the specific character of emergency nursing and about what 17 years in the emergency department at Knox Community Hospital had given me as a professional approach to crisis. Emergency nursing is not comfortable work. The patients arrive in distress. The information is often incomplete. The timeline is always tight. The penalty for the wrong prioritization can be irreversible harm. What 17 years of this work produces is not immunity to the distress of a situation. It produces the ability to maintain clinical function while the distress is present. You do not stop feeling the urgency. You channel it into the assessment and the action rather than into the response. When the title company had called, I had felt the urgency immediately. 2 weeks to closing. A lien I had not known about. A contractor who had not paid his supplier. The urgency was real and appropriate. What I had not done was let the urgency direct the response without the clinical framework. The clinical framework had been triage, assess, treat. The triage question had been, is this lien valid? The assessment had been, probably not, based on the absence of notice to owner. The treatment had been, call the attorney with the assessment already formed. The work had given me the framework. The framework had directed the response. The response had worked. 17 years of emergency nursing had protected my house. The clinical skills transfer. They transferred here. Apply what you know. The framework you work in every day is the framework for this situation too. I also want to say something about what 17 years in the emergency department has taught me about the relationship between the framework and the outcome, and about why the framework matters more than the specific knowledge in many situations. When a patient presents with a complex constellation of symptoms, a nurse who has the clinical framework, triage, assess, stabilize, treat, can apply it to any presenting situation, even one they have not seen before. A nurse who only knows specific protocols is limited to the situations those protocols address. The framework generalizes. The specific protocol does not. I had not known anything about Ohio mechanics lien law before the title company's call. I had not known about notice to owner requirements or RC 1311.05 or the discharge proceeding under RC 1311.21. What I had known was the framework. Identify the critical issue, assess it rapidly, move to treatment. The framework had directed me to pull the lien, search my records, identify the probable defect, and call the attorney before taking any other action. The attorney had supplied the specific legal knowledge. The framework had organized the situation so that the specific knowledge could be applied correctly. Together they had produced the discharge and the closing. The framework is what you have before you know the specific knowledge. Use the framework you already have. Apply it to the situation in front of you. Then find the specific knowledge with the framework as your guide. The triage framework is available to everyone regardless of professional background. The framework is, what is the critical issue? What does the evidence show about it? What is the treatment? Apply it to any crisis. The lien crisis had a clear critical issue, validity. The evidence had been clear, no notice. The treatment had been clear, challenge the validity. Framework plus evidence plus action equals resolution. Use the framework. The ER teaches you that the framework works under pressure precisely because it has been practiced under pressure thousands of times before. The triage framework is automatic after 17 years. I had applied it to the lien situation without deciding to apply it. It had simply been the way I had approached the problem because it was the way I approached every problem. If you have a professional framework that works under pressure, it works in legal crises too. Use what you know. Worked in the emergency department at Knox Community Hospital in Knox County for 17 years, and the work of emergency nursing is triage work. When a patient presents with multiple simultaneous symptoms, you identify the life-threatening one first and treat it before you treat anything else. The lien on the house was the life-threatening symptom. The refinance closing in 2 weeks was the timeline. The question was not how to feel about the contractor who had taken my money and not paid his supplier. The question was whether the lien was valid and whether it could be removed before closing. I had gone directly to the triage question. Ohio Revised Code Chapter 1311 governs. I want to explain more about why Ohio designed the notice to owner requirement the way it did and about what the legislature was protecting against. The construction industry has a specific structural problem. The person who benefits from the work and materials, the property owner, typically has a contract only with the general contractor. The general contractor contracts with subcontractors and suppliers. The owner has no knowledge of these downstream relationships. The owner cannot see whether the general contractor is paying the people they should be paying. In a world without notice requirements, an owner could pay the general contractor completely and then have mechanics liens filed against the property by unpaid subcontractors and suppliers the owner had never met. This would effectively require the owner to pay for the project twice, once to the general contractor and once to the lien claimants. The notice to owner requirement is the legislature's solution to this problem. By requiring subcontractors and materialmen to identify themselves to the owner early in the project, the law gives the owner the information needed to protect themselves. The owner who knows that a particular granite supplier is working on their kitchen can require proof that the supplier has been paid before releasing the final payment to the general contractor. The owner who does not know the supplier exists cannot take this protective step. The law responds to this by taking away the lien right from the supplier who chose not to give the owner the information. The supplier's choice not to serve notice is the supplier's risk. I had not received notice. The risk had fallen on the supplier. The lien had failed. I also want to say something about what the 21-day window means and about what happens if a supplier serves a notice after that window has passed. Under RC 1311.05, the notice must be served before the materialman first furnishes or within 21 days after first furnishing. A notice served after 21 days is a late notice. A late notice does not create a lien right for materials furnished before the notice. It may create a lien right for materials furnished after the notice, depending on how the Ohio courts apply the statute in the specific circumstances. The practical implication is that a supplier who forgets to serve notice at the start of a project and remembers halfway through cannot retroactively create a lien right for materials already furnished. The granite supplier who had filed the lien on my property had never served any notice at any time. Not before furnishing. Not within 21 days. Not at any point during the project. The absence was complete. The defect was complete. A partial notice compliance situation is more complex than the situation I had faced. My situation was clear because the absence was total. If you have received a notice to owner at any point during a project, consult an attorney about what the notice covers and what the lien claimant can validly claim. The analysis becomes more nuanced when there is a notice, even a late one. When there is no notice at all, the analysis is straightforward. The lien fails. The notice requirement is not a technicality. It is the substantive condition that creates the lien right. Without it, there is no right. A lien filed without it is filed without legal authority. Treat it as the fundamental defect it is. Challenge it directly. The supplier bears the burden to show notice was served. If they cannot show it, the lien fails. This is the law. RC 1311.05. The protection is yours. Use it. Search codes.ohio.gov for RC 1311.05. Read the notice requirement yourself before calling the attorney. The statute is specific and short. It says who must serve notice, when they must serve it, and what the consequence of not serving it is. The consequence is no lien right. Read those words directly. The protection is in those words. Mechanics liens in Ohio. A mechanics lien is a security interest in real property created by statute to protect contractors, subcontractors, and material suppliers who have contributed labor or materials to an improvement of the property. A general contractor who has a direct contract with the property owner has certain lien rights. A subcontractor or material supplier who has no direct contract with the owner has different and more limited lien rights. The critical limitation for subcontractors and materialmen is the notice to owner requirement. Under Ohio RC 1311.05, a materialman or subcontractor who does not have a direct contract with the property owner must serve a notice to owner on the property owner before they can perfect a valid mechanic's lien. The notice to owner must be served before the supplier furnishes the first materials or labor to the project, or within 21 days of first furnishing. The granite supplier had not served I want to say something about what Obiora Nweke had told me about the RC 1311.21 discharge proceeding, and about what the complaint had needed to establish to trigger the supplier's obligation to prove the validity of their lien. Under Ohio law, when a property owner files a complaint to discharge a mechanic's lien under RC 1311.21, the burden shifts to the lien claimant to establish the validity of the lien. The lien claimant must prove that the lien was properly filed, that it was filed within the applicable time periods, and, critically for a subcontractor or materialman, that the required notice to owner was properly served. If the lien claimant cannot prove notice to owner service, the lien fails. This burden-shifting design is important. The property owner does not need to prove a negative that no notice was served. The property owner needs to file the complaint and challenge the notice requirement. The lien claimant then must produce evidence of proper service. My affidavit had stated that I had never received a notice to owner from the granite supplier or any representative of the supplier before or during the renovation. This had been the predicate for the challenge. The supplier had then been required to come forward with evidence of service. They had not. They could not. The notice had never been served. The absence of evidence was itself the evidence. The lien had been defective from the moment it was filed. The discharge had confirmed what the law had already determined. Without notice, no valid lien. I also want to say something about why the burden-shifting design of the RC 1311.21 proceeding is the right approach, and about what it would mean if the burden were on the property owner instead. If the property owner bore the burden of proving that no notice to owner was served, the owner would be required to prove a negative. Proving that something did not happen is one of the harder evidentiary tasks in litigation. How do you prove that a document was not delivered to you? You have no affirmative evidence because the event did not occur. You have only the absence of the document in your records and your own testimony that you did not receive it. If the burden were on the owner, a supplier could file a defective lien and force the owner to litigate for months to prove a negative. The legislature's choice to require the lien claimant to prove proper notice reflects the right understanding of who has the evidence. The party that served the notice is the party that has the evidence, the copy of the notice, the proof of delivery, the certified mail receipt. If that party cannot produce this evidence, the inference is that the notice was not served. My affidavit had triggered the burden. The supplier's inability to produce evidence had confirmed the defect. The design had worked exactly as the legislature intended. The party with the evidence had the burden. The party without the evidence had lost. I had been protected by the burden shifting. The law had placed the burden correctly. I am grateful it did. The burden-shifting design of RC 1311.21 is one of the most practical protections in Ohio property law. File the complaint. The burden shifts. The lien claimant must produce the evidence of notice. If they have the evidence, the case becomes more complex. If they do not have the evidence, the lien fails. The design rewards the property owner who acts quickly and challenges cleanly. Act quickly. Challenge cleanly. The law supports the action. Ohio RC 1311.21 is at codes.ohio.gov. Read it alongside RC 1311.05. Together they establish the right and the remedy. RC 1311.05 says notice is required. RC 1311.21 says the property owner can discharge a lien that failed to comply with the requirements. Both statutes together are the complete tool. Read both before calling the attorney. Notice to owner on me before furnishing the countertop materials. I knew this because I had received no notice from anyone identifying themselves as the countertop supplier before or during the renovation. I had been present throughout the project. I had met everyone who had come to my house. No one from a granite supplier had introduced themselves to me, served any document on me, or notified me of their involvement in any form. If a notice to owner had been served on me, I would have received it. I had not received it. The lien had been filed without the prerequisite notice that Ohio law required for a subcontractor or materialman to hold a valid lien. Before I go on, if this story I want to say something about Mount Vernon and about Knox County and about what working at Knox Community Hospital for 17 years had meant in terms of roots in the community and about how those roots had shaped the stakes of the situation. Knox Community Hospital serves Knox County and the surrounding area, a largely rural patient population with the specific health patterns of a county that includes both agricultural work and manufacturing employment, and the full range of community members that a county seat serves. I have treated patients from Fredericktown and Gambier and Centerburg and the townships that surround Mount Vernon. I know the community in the specific way that an emergency room nurse knows it, through its moments of crisis, through the families that come in at 2 a.m, through the farmers who wait too long before coming in, and the children who are brought in immediately, and everything in between. 17 years of this produces a specific attachment to the place that has nothing to do with how scenic it is or how economically advantageous it is. It is the attachment that comes from knowing the community in its most vulnerable moments and choosing to continue to be present for them. The Chestnut Street house had been mine for 6 of those 17 years. The refinance had been the financial instrument that had been going to reduce my payments in a meaningful way. The lien had threatened both the financial plan and the stability of being rooted in the community I served. The discharge had protected both. Knox County is home. I also want to say something about what the refinance had been for, and about why the 11-day delay had mattered financially, and about what the rate environment had been at the time. The refinance had been a rate and term refinance that had been going to reduce my monthly payment by a meaningful amount. I had started the process 4 months before the scheduled closing when rates had been at a favorable level. I had locked the rate 30 days before closing at the then current market rate. When the lien had appeared 2 weeks before closing, the rate lock had been in place. The lender's rate lock policy had allowed for extensions under documented circumstances beyond the borrower's control. A title defect created by a third party's filing was exactly the kind of circumstance the extension policy had been designed for. Obiora had communicated with the lender on my behalf to document the situation and the expected timeline. The lender had agreed to hold the rate without a fee given the circumstances. The 11-day delay had not cost me the rate I had locked. It had cost me 11 days of the higher payment. This was a manageable cost. The outcome had been the one I had planned for 4 months to achieve. The lower payment has been in effect since the closing. The lien had delayed it, but had not prevented it. The discharge had restored the timeline close enough to the original that the financial plan had not been materially disrupted. The triage had been rapid enough. The treatment had worked. Knox County is the right place to be rooted. The work of the hospital and the house on Chestnut Street and the community I serve are all parts of the same life in the same place. The lien had threatened the financial instrument that had been going to make the economic part of that rooted life more stable. The discharge had restored the path to that stability. The refinance had closed. The payment is lower. The roots hold. Knox Community Hospital and the community it serves had given me the professional identity that had produced the triage approach. The approach had saved the refinance. The refinance had stabilized the financial foundation of the life I am building in Knox County. Everything connects. The professional skill had protected the personal investment. Both are part of the same rooted life. The roots hold. Knox County holds. Connects with something real in your life. Please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Makena. I am 41 years old. And this is the story of how Ohio Revised Code 1311.05 and the notice to owner requirement established that the granite supplier's mechanics lien on my Chestnut Street property was defective, and what an attorney named Obiora Nweke, who had been practicing construction and property law in Knox County for 11 years, did with that defect when the title company said the lien had to go. Now let me explain the mechanics lien. I want to say something about the kitchen renovation and about Bradley, and about what had happened with the contractor dispute after the lien was discharged. Bradley had been a competent contractor. The kitchen work had been good. The cabinets had been installed level and square, the island had been positioned correctly, the plumbing relocation for the sink had been done cleanly. The countertops were beautiful and well fitted. He had simply taken my money and had not paid the supplier he had used for the granite. Whether this had been deliberate or a consequence of his own financial difficulties, I do not know. What I know is that I had paid him for the countertops as part of the final payment on the contract, and that the payment had not reached the supplier. After the discharge proceeding, Obiora had sent a demand letter to Bradley identifying the specific damages I had incurred, the additional attorney fees for the discharge proceeding, the rate lock extension fee that the lender had ultimately waived but that I had been at risk for, and the time and cost associated with the 11-day delay. Bradley had responded through an attorney and had ultimately paid a portion of the claimed damages. The recovery had not been complete, but the kitchen is still there, still good, still the renovation I had planned for 2 years and executed with a contractor who did the work right even if he did not pay his bills right. The countertops are the best surface in the kitchen. The lien that had attached to them for 6 weeks is gone. The discharge order is in the Knox County Recorder Index. I also want to say something about the kitchen island and about what it means to eat breakfast at a counter that was planned for 2 years before it existed, and that was then nearly lost to a defective lien before the house had even been refinanced. The island is the center of the kitchen in a way that the old layout had prevented. The old kitchen had been a galley, 2 runs of cabinets facing each other with a narrow path between them and no open counter visible from the dining room. The new layout had opened the south wall and positioned the island in the center of the expanded space, with the granite countertop at sitting height on the dining room side. The morning light from the east window comes across the granite surface in a way that shows the veining clearly. I had not known this would happen when I had approved the countertop selection. It is one of the specific pleasures of owning a house that has been renovated to your plan, the small unforeseeable pleasures that the plan produces. The granite surface with the morning light across it is one of them. The lien that had attached to the surface for 6 weeks had not been able to extinguish the pleasure that was waiting on the other side of the discharge order. The discharge had made the ownership complete and the pleasure possible. The countertop is mine. The morning light is mine. Both held because our C-1311.05 held. Triage had found the defect. The law had confirmed it. The island had been saved. The kitchen had been planned for 2 years. The renovation had taken 6 weeks. The lien had lasted 6 weeks. The discharge had taken 3 weeks. All of this together had produced the kitchen I had planned. The planning and the persistence, and the law had converged on the right outcome. The outcome is the kitchen at the center of the house. It is still there, still mine, still good. Bradley had done good work on the kitchen. The work remains good. The granite is the surface he had selected from a sample board, and I had approved from a photograph. His taste in material had been better than his payment practices. The kitchen holds both facts: good work, bad payment. The law had separated them. The work had stood. The bad payment practice had produced the lien. The lien had been discharged. Both truths are in the record. Notice to owner requirement more fully and about why the legislature designed it as a prerequisite for subcontractor lien rights. The notice to owner requirement exists because of the position property owners occupy in construction projects. A property owner who contracts directly with a general contractor typically does not know the identities of the subcontractors and suppliers the general contractor uses. The owner has no direct relationship with these parties. The owner cannot monitor whether the general contractor is paying them. Without the notice to owner requirement, a property owner could pay the general contractor in full and then discover that the contractor had not paid the subcontractors and suppliers, who could then lien the property for the unpaid amounts. The owner would have paid twice for the same work. The notice to owner requirement addresses this by requiring subcontractors and materialmen to identify themselves to the property owner before or promptly after they begin work. Once the owner receives a notice to owner, the owner knows who is on the project and can verify that they are being paid. The owner can condition further payments to the general contractor on proof that the subcontractors and suppliers who have served notice to owner have been paid. The notice creates the legal relationship between the subcontractor, or materialman, and the owner that is the prerequisite for the lien right. Without the notice, the subcontractor or materialman has no legal relationship with the owner and no valid lien right against the owner's property. Obiora confirmed my analysis. He said, "I want to describe what the 20 minutes after the title company's call had looked like and about how the triage framework had organized the investigation immediately. In the emergency department, the first 20 minutes with a new patient are the most critical. You are gathering information, identifying the chief complaint, assessing vital signs, and forming an initial clinical impression that will direct the immediate treatment plan. You do not spend those 20 minutes expressing distress about the patient's condition. You spend them assessing it. I had applied this exactly to the lien situation. The chief complaint was defective or valid lien. The vital signs were 2 weeks to closing, lien filed by party I had not contracted with, no direct knowledge of his supplier. The initial clinical impression was probable notice to owner defect. The treatment plan was pull the lien, search records, confirm defect, call attorney. I had pulled the lien instrument from the Knox County Recorder portal. It had taken 3 minutes to find. I had read it carefully. No reference to notice to owner service anywhere in the document. I had opened the renovation project file I had maintained on my computer. Contract, payment records, photographs, all correspondence with Bradley. No notice to owner document anywhere. I had called Obiora with the lien instrument and the project file already reviewed. The 20 minutes had been the assessment. The call had been the treatment. Triage does not wait for certainty. It moves on the best available assessment. The assessment had been clear. The treatment had followed immediately. I also want to say something about what the Knox County Recorder portal had shown when I had pulled the lien instrument and about what the document itself had and had not contained. The lien instrument was a standard Ohio Mechanics lien affidavit form. It had the supplier's name and address, the owner's name and the property address, the amount claimed, and an identification of the improvement made. It had been notarized and signed by an officer of the granite company. What it had not contained was any statement that a notice to owner had been served on me. This absence had been significant. Under Ohio law, a mechanics lien filed by a materialman who has served a notice to owner will often reference the notice in the lien affidavit. The absence of any reference to a notice had been consistent with my own knowledge that no notice had been served. It had also been consistent with a supplier who did not consistently serve notices, and who had filed the lien without recognizing that the notice was a prerequisite for the right. Some suppliers file mechanics liens without knowing about the notice requirement. They file because they are owed money, and the lien is available to them as a remedy they have heard of. They do not realize that the remedy requires a predicate notice they did not serve. This is not an excuse for filing a defective lien, but it explains why defective liens are filed regularly. Pull the lien, read it, look for the notice reference. Then search your own records. The answer is in both places. Pull the lien from the recorder portal. Read it completely. Look for any reference to notice to owner. Then search your own files. If neither shows a notice, you have the basis for a challenge. Call the attorney with both searches already done. The 20 minutes of preparation produces a focused attorney call. A focused call produces a faster resolution. Speed mattered in my case. Prepare quickly. Move quickly. The law supports the quick move. The Knox County Recorder portal is at the county website. Search by property address or owner name. Find the lien under your name. Open the document. Read it for notice to owner references. If there are none, search your own renovation file. Both searches together take under 30 minutes. Do them before the attorney call. I had done them. The attorney call had been productive because the searches had been done. The absence of a notice to owner is fatal to this lien. He said that a materialman who does not serve the required notice has no lien right under our C-1311.05, regardless of whether the materials were actually incorporated into the property, and regardless of whether the general contractor failed to pay them. The notice requirement is jurisdictional. It creates the right. Without the notice, the right does not exist. The lien filed without the predicate notice is not a valid lien. It is a defective instrument that can be discharged by the court. Obiora filed a complaint in the Knox. I want to say something about what had happened at the Knox County Court of Common Pleas and about how quickly the discharge proceeding had moved once the supplier had been unable to produce evidence of notice to owner service. Obiora had filed the complaint on a Monday. The supplier's attorney had been served and had filed a response within a week. Obiora had immediately served a discovery request asking for all documents evidencing service of notice to owner on me. The supplier's response to the discovery request had been the turning point. They had produced no documents evidencing service because there were none. The notice had not been served. They could not manufacture evidence of a notice that had never been sent. Obiora had filed a motion for summary judgment based on the absence of any notice to owner evidence. The motion had been unopposed in any meaningful way because the supplier had no evidence to produce. Judge Agu had reviewed the motion and had found that no genuine issue of material fact existed regarding the notice to owner requirement. None had been served and the lien was therefore defective under RC 1311.05. She had entered an order discharging the lien. The Knox County Recorder had recorded the discharge order. The title company had received confirmation of the discharge. The entire proceeding from filing to discharge order had taken less than 3 weeks. A defect that is clear on the face of the record resolves quickly when it is pursued directly. Obiora had pursued it directly. The speed had been possible because the defect had been clear. A clear defect, pursued directly, resolves in weeks. I also want to say something about Judge Chioma Agu and about what her handling of the discharge proceeding had demonstrated about how the court system works when a clear legal defect is clearly presented. She had received the complaint, the supplier's response, and Obiora's motion for summary judgment with the discovery responses attached. The discovery responses had shown that the supplier had no evidence of notice to owner service. The motion for summary judgment had argued that the absence of such evidence was dispositive under RC 1311.05. No notice, no valid lien, discharge required. She had granted the motion. The grant had been the correct legal result given the undisputed facts. There was no genuine issue of material fact because the supplier had produced no evidence that could create a genuine issue. A court that applies clear law to undisputed facts quickly is a court that is functioning correctly. The Knox County Court of Common Pleas had functioned correctly. The 11-day total resolution time had been made possible by a court that had moved quickly on a clear record. The clarity of the record had come from Obiora's preparation. The preparation had been enabled by my 20-minute assessment that had identified the right issue. The chain from the title company's call to the discharge order had been short because every link had been precise. Precision at every link produces a short chain. The chain had been short enough to save the refinance. A clear defect pursued directly resolves quickly. The speed of the resolution had been the product of the clarity of the defect and the directness of the pursuit. Obiora had identified the argument, filed the complaint, served discovery immediately, and moved for summary judgment as soon as the discovery had confirmed the defect. No delay at any step. 11 days from the original scheduled closing. Close enough. The refinance had closed. The rate had held. Speed had been possible because the defect had been clear. Obiora Nweke practices in Knox County and had handled this specific type of case before. When you are looking for a construction or real estate attorney to handle a mechanic's lien discharge, ask specifically about their experience with RC 1311.21 proceedings and notice to owner defects. An attorney who has handled these cases will move quickly and correctly. Speed and precision had been essential in my case. Find the attorney who provides both. County Court of Common Pleas to discharge the mechanic's lien under Ohio RC 1311.21, which provides the procedure for contesting a mechanic's lien. He attached my affidavit stating that no notice to owner had been served on me and my detailed account of every person who had appeared at the property during the renovation, and the fact that no one from a granite or countertop supplier had identified themselves to me. The supplier's attorney responded to the complaint. When asked in discovery to produce evidence of notice to owner service on me, the supplier was unable to do so. There was no evidence because no notice had been served. Judge Chioma Agu, who had been handling civil matters in Knox County for 8 years, reviewed the evidence and found that no notice to owner had been served. She ordered the lien discharged. The Knox County Recorder discharged the lien from the record. The title company received the discharge. The refinance closed 11 days after the original scheduled closing date. I want to say something before I go. I want to end with something about the kitchen and about what it looks like now and about what I think about when I am standing at the granite countertop that was the subject of the lien. The countertop is gray with warm brown veining that the supplier's representative had called antique white when Bradley had selected it for the island. I had approved the selection from a photograph. It is more beautiful than the photograph had shown. The island is 42 inches by 24 inches and the overhang on the dining room side creates a breakfast counter where I eat in the mornings before the night shifts. I had wanted this specific configuration for 2 years before the renovation. The configuration exists now exactly as I had planned it. The lien that had attached to this countertop for 6 weeks was a claim filed without the legal prerequisite that Ohio law required. The law had been clear on this point. The attorney had applied the law correctly. The court had confirmed the application. The discharge had followed. The countertop is mine in every legal sense. The granite supplier had a legitimate grievance against Bradley. They had not had a valid claim against my property. The notice to owner requirement is the boundary between those two things. On one side of the boundary, a valid lien. On the other side, a dischargeable defect. I had been on the right side of the boundary because the notice had never been served. The boundary held. The discharge held. The countertop is still there. Every morning at the breakfast counter, I remember that it is mine because RC 1311.05 held. It will hold for you too if you use it. Read the statute. I also want to end with something about what working in the emergency department has taught me about recovery, and about what recovery looks like in a legal context versus a clinical one. In the emergency department, recovery from a crisis episode begins with stabilization. The acute threat is managed. The vital signs are brought to a safe range. The patient is transferred to the appropriate level of care for ongoing treatment. Recovery is not the same as the original healthy state. The patient who presents with a cardiac event and is stabilized and transferred to cardiology is not the same patient they were before the event. They carry the event and its treatment as part of their health history. The property on Chestnut Street carries the mechanic's lien and its discharge as part of its title history. Both the event and the recovery are documented. The documentation is not a defect. It is a record of a crisis managed correctly. The property is stable. The title is clean. The refinance closed. The payment is lower. The kitchen island is the center of the morning routine. The granite countertop catches the light. All of this is possible because the triage had been rapid and the treatment had been correct, and the law had confirmed the clinical assessment. The law had been clear. The notice had not been served. The lien had not been valid. The discharge had followed. Ohio RC 1311.05. Read it. If the notice was not served, the lien is not valid. The law holds this boundary. Use the law. It held for me. Every morning at the breakfast counter before the night shift, I sit at the granite surface that was once the subject of a defective lien that had no legal basis. The surface is smooth and cool in the morning. The light is east. The coffee is ready. The shift is at 7. All of this is mine, and is mine clearly and will remain mine because the law held the boundary, and I had used the law. RC 1311.05. The notice had not been served. The lien had not been valid. The discharge had confirmed it. The boundary holds. Not about the contractor who had not paid his supplier and who I had pursued separately for the resulting costs. About the triage principle and about what the emergency nursing had given me and about why triage had been the right framework for a situation that would have paralyzed someone else. In the emergency department, a patient who presents simultaneously with chest pain, shortness of breath, and a bleeding laceration needs the cardiac and respiratory symptoms treated first. The laceration can wait. Treating the laceration first because it is visible and obvious, and the cardiac symptoms are internal would be the wrong clinical decision. You identify the life-threatening symptom, treat it, stabilize the patient, then address the secondary issues. The mechanic's lien had been a presenting symptom with a tight timeline. The triage question had been, is this lien valid? The clinical answer had been no. The treatment had been a complaint to discharge. The patient had been stabilized. The refinance had closed. Thank you for staying until the end. I want to say something about what property owners can do proactively to protect themselves from mechanic's lien exposure before a lien is ever filed. The best protection is to understand the notice to owner system before you hire a contractor for any renovation project. When you engage a general contractor for a project that will involve subcontractors or material suppliers, include a provision in your contract requiring the general contractor to notify you of all subcontractors and suppliers as soon as they are engaged. Include a requirement that the general contractor provide lien waivers from all subcontractors and suppliers as a condition of each progress payment. A lien waiver from a supplier states that the supplier has been paid and waives any lien right for the materials covered by the payment. If you receive a notice to owner from a subcontractor or supplier during the project, keep it and use it. Require proof of payment to that specific supplier before releasing the final payment to the general contractor. A general contractor who cannot provide lien waivers from parties who have served notice to owner has not paid those parties. Do not release the final payment until you have the waivers. These steps would have prevented the situation I had experienced. I had not known to include these provisions before the kitchen renovation. I know now. I will include them in every future renovation contract. The knowledge came at a cost. Share the knowledge so others do not pay the same cost. Include the lien waiver requirement. It costs nothing to include. It can prevent everything that the absence of it produced for me. I also want to say something about what the Knox County Recorder's Index now shows for the Chestnut Street property and about what future buyers or lenders will find when they search it. The index shows my deed, the original mortgage, the refinance mortgage, the mechanics lien filed by the granite supplier, and the discharge order entered by Judge Agu. 5 instruments. The last 2 instruments tell the complete story of the lien situation, filed and discharged. A future title examiner who finds the lien in the index will immediately find the discharge order in the same search. The lien is gone. The discharge confirms it. The title is clear. No future buyer or lender will face the issue I had faced because the issue has been resolved and documented in the public record. This is what the discharge proceeding produces beyond the immediate resolution, a permanent public record entry that answers the question of the lien for all future inquiries. The lien that might have clouded my title for years has been documented as discharged. The cloud is gone. The title is clean. Future refinances, future sales, future title examinations will all find the same answer in the recorder index. The lien was filed. The lien was discharged. The title is clear. Obiora had said, the discharge order in the recorder index is as important as the discharge itself. The public record holds the answer for anyone who needs it. The answer is clear. The title is clean. The recorder portal holds the complete title history. Anyone who searches the Chestnut Street property now will find the lien and the discharge in the same search. They will understand that the lien was filed, challenged, and discharged. The title is clean. The record confirms it. The recorder holds the answer for all future inquiries. The answer is clear and permanent. This is what the discharge produces beyond the immediate relief. A permanent, clear record, valuable in every future transaction. If you are selling the property or refinancing and a title search finds a mechanic's lien you were unaware of, the first question is the same as mine had been. Was notice to owner served? If not, the lien may be dischargeable. Do not pay an unverified mechanic's lien to clear title before you have determined whether the notice requirement was met. The payment may be unnecessary. The discharge proceeding may be available. Verify first. Pay only if the lien is valid. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a homeowner whose contractor had served a valid preliminary notice and whose mechanic's lien had been properly perfected, and what Ohio law had required in terms of payment procedures to protect against that lien, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if a mechanic's lien is filed on your property by a subcontractor or material supplier you have never heard of, before you assume you owe the money, ask whether they served a notice to owner on you before they began furnishing materials or labor to your project. If they did not serve notice, their lien right under Ohio RC 1311.05 may not exist. A defective lien is not a valid claim. The notice requirement is the law's way of making sure property owners are not blindsided by claims from parties they never met. I had not been given notice. The lien had not been valid. The discharge had followed. The refinance had closed. I want to tell you more about Mount Vernon and about Knox County and about what the Chestnut Street property had meant to me and about the kitchen renovation that had started everything. Mount Vernon is the county seat of Knox County in central Ohio, south of Mansfield and northeast of Columbus, a small city with a well-preserved historic downtown and the specific character of a county seat that anchors a largely agricultural county. The city has the quality of a place that has maintained its civic identity over generations: a courthouse square, a working downtown, established residential neighborhoods with houses from the late 19th and early 20th centuries that have been continuously occupied and maintained. Knox County has a mix of agriculture and small manufacturing and the educational presence of Kenyon College a few miles south in Gamber, which gives the county a cultural dimension that not every rural Ohio county has. The Chestnut Street property had been a 2-story house built in 1924 that I had purchased 6 years before the refinance. The house had the specific character of early 20th century residential construction in central Ohio: solid framing, plaster walls, hardwood floors that had been refinished twice since I had moved in, tall windows that gave good light in the front rooms and needed new weather stripping every few years. The kitchen had been the original kitchen, small for a modern household, with a layout that had made sense in 1924 and had not made sense since approximately 1970. The renovation had been planned for 2 years before I had executed it. New cabinets, a center island, quartz countertops, and a reconfigured sink and dishwasher position that opened the kitchen to the dining room. I had taken bids from 3 contractors and had selected the one whose references had checked out and whose timeline had been realistic. His name was Bradley. He had performed the work competently. The work had been good. He had simply not paid his supplier. I want to say something about the specific moment when the title company had called and about what I had done in the first 20 minutes after hanging up. The call had come on a Thursday morning when I was at home before a night shift. The title company's representative had read the lien information to me, the supplier's name, the lien amount, the date of filing. I had written all of it down on the notepad I keep by the phone for exactly this kind of information. When I had hung up, I had gone to the Knox County Recorder's online index and had pulled the lien instrument. I had read it. The lien had been signed by an officer of the Granite Company and had stated the amount claimed. And I want to say something about what any homeowner who receives a mechanic's lien from a party they have never dealt with should do before assuming the lien is valid and before agreeing to pay it. The first step is to pull the lien instrument from the county recorder's index. The lien instrument is a public record. County recorder portals are searchable by property address or owner name. Find the lien. Read the lien. The lien will identify the claimant, the amount, the property, and the basis for the claim. Look for any reference to a notice to owner having been served. Then search your own records for any notice to owner document you may have received from the claimant. A notice to owner is a specific written document that identifies the supplying party, the project, and the property. If you did not receive one before, or within 21 days of the first furnishing, the lien may be defective under RC 1311.05. The second step is to contact a construction or a real estate attorney in your county with the lien instrument and your search results. Ask specifically about the notice to owner requirement and whether the absence of a notice is a basis for challenging the lien. Do not pay a mechanic's lien from a party you never contracted with before you have determined whether the notice requirement has been met. The notice requirement is the law's protection for you. I had used it. The protection had worked. Obiora had applied it. The lien had been discharged. The refinance had closed. I also want to say something about the lien waiver and about what it is and how to use it in practice on a renovation project. A lien waiver is a document signed by a contractor, subcontractor, or supplier that waives their right to file a mechanic's lien against the property in exchange for payment received. There are conditional lien waivers and unconditional lien waivers. A conditional waiver waives the lien right upon receipt of a specific payment. An unconditional waiver waives the lien right absolutely for work or materials covered through a specified date. On a kitchen renovation project, a properly structured payment process looks like this. The general contractor provides a conditional lien waiver from themselves and from each subcontractor and supplier who has served notice to owner, signed in exchange for each progress payment being released. Before the final payment, the contractor provides unconditional lien waivers from all parties confirming that all amounts have been paid and that no lien rights remain. This is standard practice on commercial construction projects. It should be standard practice on residential renovation projects too. Most homeowners do not know to ask for it. I had not known to ask for it. Now I know. Include the lien waiver requirement in the contract before you sign with any contractor. The contract clause is one sentence. The protection it provides is complete. A contractor who has paid all their suppliers will have no difficulty providing the waivers. A contractor who balks at the requirement is telling you something about their payment practices. Include the lien waiver requirement in every renovation contract you sign. It is one sentence in the contract. The sentence is, contractor shall provide unconditional lien waivers from all subcontractors and materialmen as a condition of each progress payment and of the final payment. One sentence. It costs nothing to include. It protects everything. I did not include it. I know now to include it. You know now. Include it. The lien waiver clause in a contract is a standard provision in commercial construction. Residential contractors may push back on it because they are not accustomed to it. Hold firm. A contractor who will not agree to provide lien waivers is a contractor who cannot promise that their suppliers will be paid. That is not a contractor you want on your renovation. The waiver clause is a screening tool as well as a protection. Use it as both. Had identified my property as the property on which the lien was claimed. I had then looked for any reference in the lien instrument to a notice to owner having been served. There was none. I had searched my own records, the renovation contract with Bradley, the payment receipts, the project file I had maintained with photographs and correspondence. There was no notice to owner document anywhere in the file. There was no letter, no certified mail receipt, no in-person service documentation, nothing from any granite or countertop supplier. In 20 minutes I had established the probable defect. The triage assessment had been rapid because the framework had been clear from years of emergency nursing. Identify the critical issue, assess it quickly, move to treatment. I want to say something about what Obiora Nweke had told me about how the notice to owner requirement operates in practice in Knox County kitchen and bathroom renovation projects, and about why the failure to serve notice is so common and yet so consequential. He had said that in small renovation projects where a general contractor is engaged to complete a kitchen or bathroom remodel, the subcontractors and materialmen are often small local suppliers who do not have dedicated legal staff and who do not consistently follow the Ohio Mechanics lien notice procedures. A granite or countertop supplier might supply countertops to dozens of kitchen renovation projects in a county without serving notice to owner in any of them because the owners typically pay the contractor typically pays the supplier, and the lien process is never triggered. The notice requirement only becomes consequential when the contractor does not pay the supplier. At that point, the supplier tries to lien the property and discovers, if the property owner has legal representation, that they do not have the predicate notice right. He had said that the notice to owner requirement under RC 1311.05 had been designed to protect property owners in exactly this situation. A contractor who had been paid in full had failed to pay a downstream supplier, and the supplier was attempting to make the property owner responsible for the contractor's failure. The owner who has received a notice to owner from the supplier can protect themselves by requiring proof of payment to the supplier before releasing funds to the contractor. The owner who has not received a notice to owner cannot take this protective step because they do not know the supplier exists. The law's response to this asymmetry is that the supplier who did not serve notice cannot lien the property. The law places the risk of contractor non-payment on the supplier rather than the owner when the supplier chose not to serve the notice that would have allowed the owner to protect both of them. I want to say something about what the 11-day delay in the refinance closing had cost me and about why the mechanics lien discharge process had worked as quickly as it had. The refinance rate I had locked had been held by the lender for 30 days beyond the original closing date because Obiora had communicated with the lender directly and had explained the legal situation and the expected timeline for the discharge proceeding. The lender had agreed to extend the rate lock without a fee given the circumstances. The additional legal fees for the discharge proceeding had been partially recovered in the contractor dispute. The delay had been an inconvenience and an expense but not a catastrophe. The speed of the resolution had been a function of a specific defect. When the lien is defective because no notice to owner was served, the defect is either provable or not provable within a short period. If the supplier has proof of service, the case becomes more complex. If the supplier has no proof of service, as had been the case here, the defect is established quickly. The supplier's inability to produce evidence of notice in response to Obiora's discovery request had resolved the case on its factual merits before any extended litigation had been required.